as judges to decide whether or not we accept. I don't want anyone coming and saying because we said question and answer, so if the person should have said, for example, we ask a question. I'm trying to be careful how to come. There are how many? Yeah. So we ask the question, name the vowel letters. And because we arranged it as A-E-I-O-U, somebody decided to say I-E-A-U, we will still accept it. Why? Because there's a vowel letter and all of them have been called, right? Instead of us saying no, for the fact did not say A-E-I-O-U, so we can accept it. I hope we're clear. All right, with that,
please listen.
question number 1. What is copyright infringement?
Copyright infringement is an unauthorized use of work without the creator permission or the copyright owner.
Thank you. Correct. My coach also asked the next question.
Name one example of related rights in copyright law.
Performance rights.
Name one example of related right in copyright law.
Performance.
Okay.
So you are correct. Performance right is one of the related rights, and in our comments for the project presentation, one of the schools even made a mistake when they said related rights and they started to name trademarks, patent. I had an issue, but it's on my comments, so I'm doing it. I will speak to that. Copyright is for the author, the original owner of the work, and then related rights are the contributors. So, for example, the producer is a related right, the performer is a related right, the broadcaster is a related right. So, your answer is correct. We will move on to the next judge.
What is an industrial design in intellectual property law?
So, in intellectual property law, industrial designs basically has to do with the shape, the size, and all other industrial designs that are done on certain brands or that a brand carries. For example, you're looking at Aqualife. Their industrial design is different from that of Diamond Waters. So, in my own words, that's industrial design. Industrial designs are visual designs that you can see or that is visible. For example, on let's look at the apple. So those are industrial designs. The apple sign represents the industrial designs. And also the Aqualife bottle, the size of the Aqualife bottle and the shape also it differs to that of the Diamond Water.
Yes. It's clear because it's talking about shape, it's talking about visual design. So will give you the 5 points.
So the answer again, like we said, we will be looking for keywords. When you're speaking of industrial design, basically you'll be talking about the visual design that comes with that particular product relatively to the shape, like the pattern or even the color. And you are very key to even give an example right before us. This particular design of this bottle is attributed to Aqualife. So you find all water in bottles, but their bottle design is not like this, right? So it's in a different shape. The design here, this pattern of line is so unique to them. So again, you are correct for 5 points. Wouldn't you want to go for the last questions?
What is patent?
So, a patent is a right given to an inventor. So it's a right given to an inventor to stop there because, for instance, in our story where the Casal Grandor, the Casal Grandor is an inventor, right? So we have the right. So the right we have is a patent. A patent, sorry, a patent.
Go again.
A patent. So, like I said, in our story where we illustrated the Casal Grandor, so the right that is given to that Casal Grandor, which is the inventor of the Casal Grandor, the right that is given to him is called the patent, or the exclusive right that is given to him is called the patent.
Give you a last opportunity to break.
So, like I said, a patent is a right or an exclusive right that is given to an inventor that allows him or not to use his own work.
So I think you missed, but that's when you go back to. So the thing is, the patent is a legal right granted to an inventor, giving an exclusive right to use, make, and sell, that invention for a certain period. So there are few keywords you use, like legal rights, exclusive in certain period. These are keywords that you need. So you got 2 points.
Yeah.
So, according to you said that we are not forced to give it exactly. This is something that you have so many things on my mind also. So, this is something that perhaps. Chief. Yes, sir. Chief. Yes, sir.
You see that the power we consider 1, consider 2, consider 3, the 3 point. Then I issue. But I go to you, I'll go to point to you. Alright, so you guys did well. At least he was sitting looking at him. He asked the question. So out of the 20 points, you guys got 17. I think it's a congratulations for you. Just I get there, but they needed to come clearly because we might go back on that question. Thank you so much.
Thank you ever so much, St. Peter Clever Catholic High School. Let's now program the demo programs in United Methodist High School.
Again, we want to remind the teachers your club record. The activity has now come and it is 10 points.
While the question is going on, we request your club record presentation also.
The activities you conducted, the number of times you held sections.
We have remaining work on student programs. Can we proceed with We proceed.
Bromsky, how you doing? What is the difference between a registered trademark and an unregistered trademark?
Thank you. The difference between a registered trademark and unregistered trademark is that a registered trademark is a trademark that has legal protection in case the owner an exclusive right, while unregistered trademark does not have legal protection. And also high moral rights.
You won't give me the answer again?
Yes, of course.
Go ahead.
A registered trademark is a trademark that has legal protection and exclusive right and a moral limited right. While unregistered trademark is a trademark that does not have legal protection and exclusive right.
The answer coming, well, that is something involved in it. And the purpose of the applicant is to give you the knowledge, right? So when I see the leg coming going off, I know there is something there. Here you're talking about moral rights. Moral rights goes to copyright. But then what grabbing my attention is the fact that you already stated that registered trademark that has legal protection. That is what grabbing my attention, which is the definition. It must be registered and recorded with the government, thus giving that legal protection. While on registered trademark, we have some limited rights, though they are there, but it is not recorded with the office. So with that answer, I will give you 4 points.
What does public domain mean in copyright law?
Yeah. Public domain means when in public domain are not protected by copyright and can be freely used by anyone.
5 points.
What is a repo and what is its purpose? What is a repo and what is its purpose? What is a repo and what is its purpose?
Yeah. ARIPO stands for African Regional Intellectual Property Organization, and its purpose is for protecting and promoting intellectual property rights, promoting and protecting intellectual property rights among other African countries.
Okay, you got it.
Thank you. You got the 5 points. So ARIPO, like you already stated, is the African Regional Intellectual Property Office, and they are there facilitating the promotion of IP amongst African countries. They came together as a result of international treaties. And so IP works in this form and manner. You have at the international level, you have the regional level, and you have the national level. So at the national level, you have our national office, Liberia Intellectual Property Office. At the regional level is where you have the Africa Regional Intellectual Property Organization. I won't call it international level because there is a question here that relates to it, so I will leave that up. Well, you did well. So our last question for the last question, there is 4 questions per school. What is fair use under copyright law? There was a whole presentation here on fair use. We went to quote them all.
Thank you. A fair use is a legal doctrine that allows limited work. A fair use.
Let me see. Where let me see. Yes. Yeah, all understand. Let me see. Give me that phone. Open it. Let me see. Take that phone. Let's see. Your answer is only. I only want to make sure. Is clear? All right. We're trying to build a competition as free and fair. Eh? All right. Now, how is that? Yeah. No, your answer, your own part. I say, let me see. So go ahead. Don't get to tell me what happened. You are actually on path. So when you want jump from on path, now you go to different place, no problem. That particular answer you are giving, you are on path.
Fair use is a legal doctrine that gives limited right to a producer to use or work.
You started right, but you're ending up.
With I see permission from the original owner.
Is that your final answer?
Fair use is a legal doctrine that gives limited right to a producer without seeking permission from the original owner.
For what purpose?
For releasing.
For what?
For criticizing. For criticizing, broadcasting, news reporting, and researching.
So, with all of the running around you have done, just someone asking and give me the answer. Because you have touched around, there is light, put it, yeah, we don't understand it. Don't put yourself no stress. The idea is there. I don't want to see it coming. What is fair use?
Fair use is a legal doctrine that gives limited rights to a producer. I get limited right to a producer for not seeking permission from the original owner, such as broadcasting, news reporting, sound recording, and researching.
All right, so fair use is this legal principle that allows a person to use a copyrightable work, meaning the work is protected without the permission of the owner. Howbeit, that use is limited to purposes such as research, criticism, news reporting, and that's why I said you own path, but you're not saying the confidence in yourself. All right. So we'll give you 3 points. Thank you. So we're back. So
Thank you to everybody
thank
that
you so much. You
listened.
got 17 points.
Thank you.
Which school?
Let's now go to the Paso High School. Paso High School. Please be patient. Step. Don't worry. Eating meeting. No season meeting. Are you guys ready?
First question. Can copyright be transferred or licensed to others?
The answer, yes. Copyright can be transferred or licensed to others on certain terms.
5 points.
What is copyright infringement? No, we asked that question already. What is infringement in the context of trademark law? What is infringement in the context of trademark law?
The answer, infringement in the context of trademark law can take place when an existing trademark have been used by another person without the permission of the person who has the real copy.
Come again. What is infringement in the context of trademark law? Come again.
Infringement in the context of trademark law